Hello and welcome everyone to Immigration and Jobs Talk Show. I'm Nipasa Pradhan and I'm going to be your host for today's session. But before we start off with today's webinar and I'll introduce you to the topic and the guest, I have this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, welcome everyone to Immigration and Jobs Talk Show, and I'm really excited to have you all join us. So, we are streaming live right now on YouTube, LinkedIn, and Facebook. And I'm really happy to tell you that this is going to be a very participative session as well. So, wherever you're watching, please feel free to drop your comments. If you have any questions regarding the topic, especially, please feel free to drop them because we will be having none other than our special guest for today, attorney Chand Parvathaneni, an experienced immigration attorney and managing partner at Sim Parvathaneni and Brown. So Chand will be guiding us through the complexities of H1B, change of status, and answering your pressing questions. So please, without further ado, help me welcome him to the show. Hi, Chand. How are you doing today?
Hello, Nipasa. I'm pretty good, and we'll probably have a very productive discussion on the H1B and the things surrounding the change of status that kicks off on October 1st for many folks.
Absolutely. So fiscal year 2025 starting October 1st. I know there are so many folks out there who are, you know, excited about this upcoming fiscal year. So what can folks out there expect from today's discussion, Chand?
So, I mean, like you rightly pointed out, October 1st is the start of the new fiscal year, and in the immigration world, the fiscal year 2025 starts on October 1st, 2024. So, in the employment-based immigration and a lot of other immigration filings, October 1st has a big significance. Green cards, for example. October
Mhm,
1st is the day when the green cards get reset. H1B. H1Bs gets reset, and the people who are applying for H1B for the very first time. October 1st
mhm,
is the start date. So a lot of things happen on October 1st. And today, what we will target is from an H1B perspective. So, from an H1B perspective, a lot of folks who recently went through the lottery, uh,
mhm,
their companies have already applied and they probably got approvals, and some people are probably still waiting for approvals while their F1 EAD cards are expiring. So there are a lot of questions surrounding what to do if you get an approval because it's the first time H1 that starts on October 1st. Things will change. Things on how your payroll is processed. A few things will change. And what if you do not get an approval and the case is still pending? And your F1 EAD, your OPT EAD card has expired or is about to expire. So,
mhm.
challenges surrounding that October 1st start date for people who are on H1B who got an approval or waiting for an approval, and also for the folks who have applied for H1B a couple of years back. Normally, H1B can be applied only for 3 years. So, if somebody applied for a H1B October with the start date of October 1st, 2021, their expiration date is going to be 9/30/2024. And what that means is they have to ensure that they are filing for extensions for themselves through their company and also for their dependents because 9/30 is when many people's H1 expires, especially from the previous years. So things around this October 1st, what kind of pointers people should pay attention to, what kind of common issues that we see. I think these are the kind of questions that I think we will talk about today.
Absolutely, we will. And I'm sure folks out there are very excited. I can already see some comments. So I'll quickly say hi. Hi, Kumar Raj, Vishnu Vardhan, Anila. Thank you so much for joining and for already having your questions. I would just say stay with us. We have just started this session today, so we will take up your questions. All right, Chand, I hope you two are very excited for the questions we have today. And without further
Yes.
ado, friends, today's topic, as you can see, it's on the screen, facing H1B change of status challenges. I'm sure folks out there have a lot of challenges, and you may ask your questions. Please feel free to join the discussion with us. So here we have Chand Parvathaneni. And I have the first question for you, Chand, and that is with regard to pending change of status. If someone's change of status from F1 to H1B is still pending, can they continue working after October 1st if the petition hasn't been approved?
So for somebody whose change of status from F1 to H1 is still pending, normally folks on F1, they typically tend to have the OPT EAD cards, and some
Mhm.
people will also probably work on CPT status. And this question
Yes.
is more for people who are on uh, OPT status. If their EAD card is still active, they're good to work. There is no issue with working even after October 1st start date if the H1B is pending. And for
Mhm.
anybody that is on CPT, curricular practical training, they're also allowed to work as long as they're meeting the requirements of CPT, meeting the requirements of the school as far as the class attendance is concerned.
Mhm.
And then we have some folks out there whose EAD cards expire. So those are the folks that have to worry because we have something called cap gap, and cap gap gives permission for people whose EAD card has expired to work until September 30th. And after September 30th, they have to stop working, and they have to wait until their H1B is adjudicated. So normally what we suggest is for anybody whose EAD card is expired or about to expire, or they do not have CPT based authorization, the best course of action at this point of time is do not wait longer. Definitely upgrade your
Mhm.
case, try to get an adjudication, because you would need the H1B to start working if your EAD card and your work authorization expires. So some people might be able to work, but many folks whose EAD card expires, their cap gap will expire on 9/30/2024.
Okay. So there you go, friends. You have that answer at least. And thank you, Chand, for the detailed explanation. Now I have another question, and this is regarding grace period after layoff. And if a person was recently laid off from their H1B job and is approaching the end of their 60-day grace period, what options do they have if they haven't found a new sponsor yet?
Sure. So if a person on an H1B visa was recently laid off, the first thing they have to worry about is their 60-day grace period. And if they're approaching,
Mhm.
they're getting very close to the 60-day grace period and they have not secured a job, definitely, I mean, their options are kind of getting narrowed down. But in terms of the options, ideally, the first option is try to find a new H1B sponsor. If you find a new H1B sponsor, there is no problem. They're good to apply, they're good to stay back in the country. However, assuming for some reason they are about to hit the 60-day period, they're probably on the 59th day, for example. More than likely, there is no employer that can file the H1B petition that quickly because more than likely they don't have an LCA. So at that point of time, if they need to stay back in the country, the best course of action is to change their status to another visa category. And the most common visa categories that I see people change because they're close to their 60-day deadline, the grace period is ending, they do not have a new job offer. So people typically can convert to B2. So if they need to stay more time in US to wrap up their affairs, they can simply change their status to B2. It's an online application. So they can simply go online to USCIS website, type in I539 online, click on it, create a USCIS account, and start filling up that form. It takes about 30 minutes to fill up that form. It costs $470, but that is one very good way of converting, changing their status to B2, applying for B2 status, and they can stay back. And the max they can stay back is typically 6 months or until the date USCIS makes a decision. So they have to be cautious, but at least they get a little bit of buffer by filing for B2. This is what I see a lot of people do who have been on H1, lose a job, and not able to find a sponsor by 60 days. The other option, the other visa category that I've also seen people do is change of status to F1 visa, student visa. A lot of the folks out there, sometimes they see the job market is weak or they don't have the right skills. And what they try to do is they just try to get an admission in a college where they can do a course of their liking, and they have to file for F1 change of status. This also can be done online. The only caveat is that they have to have an admission from a US educational institution. They have to get a form I-20. But once they have it, they can do this F1 change of status also online. So that's also another option for folks out there who want to take a break from their job and want to spend some time in getting a degree. So that's one option. And one uncommon option that I've been seeing people try nowadays is something called O1 visa. So O1 visa is an extraordinary ability visa. It's a non-immigrant visa. But if somebody is able to prove that they have extraordinary ability in their field, they might be eligible for O1 visa. And O1 visa is also something that I think a lot of folks who might have such skills, such high level skills, such high level extraordinary ability, they might be able to focus on O1 visa also. And again, the final option, worst case scenario, if they're not able to secure a new H1B sponsor, they don't want to stay back in the country on a tourist visa, they don't want to convert to F1 status, one has to be very cautious. They have to leave the country before the 60-day grace period is up. And doing so, they're not going to violate their immigration status. If not, if they violate their status, stay back after 60 days, in the future, they might have an issue. So the 60-day grace period is something that everybody has to be very cognizant of and ensure they're not missing the 60-day grace period.
Absolutely. It's very important. And thank you so much, Chan. So, folks, you have different options out there, and it's always best to consult an expert, and that would be an attorney. So, get yourself, a consultation, and it's always best to go to the right direction. Thank you, Chan, for the detailed explanation. Moving on, I have another question, and this is regarding transferring H1B after I-140 approval. So, can a person transfer their H1B to a new employer after their I-140 has been approved? And how does this impact their green card process?
So a person can definitely transfer their H1B to a new employer, and this is even after their I-140 is approved. And there are a few things. So when a I-140 is approved and the person wants to transfer an H1B, the H1B can be transferred. The I-140 does not automatically transfer. So the minute they get a H1B approval, yes, they're good to start working at the new employer, but the I-140 does not automatically transfer. And there are two rules after I-140 approval. The
Mhm.
rule is, if the I-140 is approved and the time duration that has passed. So if 180 days has passed after the I-140 has been approved, things are going to be a little bit more advantageous to the H1B beneficiary. The reason is, after 180 days, even if the employee moves to a new company, the I-140 cannot be withdrawn. What that basically means is that I-140 can be used by the employee to file for transfers down the line. So they can use that same I-140 even if that employer wants to revoke or withdraw that H1B, that or that I-140 approval. They can still utilize that I-140 approval to get extensions, H1B extensions, get H4EAD cards, and all those things. So the 180 days is a very, very important rule. But in case somebody does not wait for 180 days and they leave the company before 180 days, in that case, what normally happens is the I-140 can be withdrawn. The I-140 cannot be used for future H1B extensions. The I-140 cannot be used for H4EAD. However, the priority date. So in the future, whenever the new company does the I-140, they will get that I-1 that priority date back. So the priority date can still be ported. The only problem is, if you don't cross 180 days after I-140 approval, you cannot really use it for the extensions or the H4EAD. So that's pretty much the main problem if you don't wait 180 days. But in general, a lot of folks out there, especially from India, India is a very, very severely backlogged country. So right now, people who have filed their I-140s, they started their perm process in 2012, they are eligible to get a green card. So even if somebody has a I-140 right from 2013, they can't still get a green card right now. So what that means is, it is just natural that people keep changing jobs even after I-140 is approved, because for somebody from India, it takes such a long time to get the green card, and in between this duration, people keep getting good career options. So the bottom line is, people should still look for good career options. If they get a good employer, they find a good job, they should be good to change their employer. The only thing is, if somebody waits for 180 days, typically they'll be in a very good position, because that I-140 typically cannot be withdrawn after 180 days.
Hello, everyone. Welcome back to Immigration and Jobs Talk Show. I'm Nipasa Pradhan, and I'm so sorry about the disconnect suddenly, but we were on with Attorney Chand Parvathaneni, and we were talking about I-140. And, if can a person transfer their H1B to a new employer after their I-140 has been approved? And how does this impact their green card process? Chand, if you don't mind, going it
Sure.
over a bit again.
Sure. Sure, Nipasa. So I'm not sure where we stopped off. I think we had like some internet
Yeah.
issues in between. But in general, one can have an I-140 approval and then they can still transfer their employer to a new employer. The new employer is going to file the H1B. And people should be conscious of a 180-day rule. The 180-day rule is if your I-140 is approved and you wait for at least 180 days, even if you transfer your employer, the new employer can you reuse the I-140 for their H1B extensions, and you can reuse that I-140 approval for H4 EAD card approvals. Uh, the only problem is if you don't wait for 180 days, the problem is you can still retain the priority date. So the priority date can still be retained even if you don't wait for 180 days. But the new company has to do an I-140 before your 6 years is up. Otherwise, you can't do H1B extensions. So the I-140 process has to be done as quickly as possible with the new employer if you don't wait 180 days. However, if you wait for 180 days, the new employer can take their own sweet time because the dates are not current for Indian nationals, and they can do it when it gets closer to the I-1 to the priority dates. So as long as people are conscious about that 180-day rule, in general, transfer of an employer even after I-140 approval should not be a challenge.
Thank you so much, Chand, for taking that up and for the detailed explanation. Now, I have another question, and this is, about switching from H1B to F1 after grace period. So, if a person has crossed the H1B grace period, but their employer hasn't officially terminated them, and they have remaining semesters to complete an EMBA program as an ex student, can they change their visa status from H1B to F1, with day one CPT? If a petition is filed, what documents might USCIS request to support the change of status?
So anytime somebody completes the grace period, so normally what grace period means is the grace period only starts if somebody has been officially terminated. So in this case, I think if somebody has not been officially terminated, so if there is no termination, then the grace period does not even start because technically they are still on a valid status. So if somebody is not terminated from a job, they should be able to file change of status to F1. So clearly in this case, he has remaining semesters. So he has already got the admission. So all he has to do is get the I-20 and then use that I-20 to file for change of status. So they should be able to do it right away. And this is assuming that this person has not been officially terminated. However, if the termination has
Okay.
occurred, and that is when the grace period starts, the day somebody is terminated from a job. And from that date, you count 60 days. And even within those 60 days, also, you can do the change of status to F1. But you are terminated and you cross 60 days, then you're out of your grace period, then you're not in authorized status. And what that means is even if you file for a change of status to F1, more than likely, if USCIS notices that you have crossed 60 days, they will deny that change of status request. And normally, what we suggest in those kind of cases is get the I-20, take the I-20 and get visa stamping, and then come back to US. So if grace period is officially over, the best course of action is to go out of the country and get stamping and come back after consular processing, which is basically getting the F1 visa. However, if there is no termination, then potentially you don't have any issue at all. Simply file for change of status, and more than likely, you should not see an issue.
All right. Thank you so much, Chand, for giving us an overview and for explaining it so well. Now, quickly at this point, I would really like to say thank you so much, folks, for joining and for your questions already. Satish, Anila, Kumaraj, Vihan, Yugandhar. Thank you so much, everyone. We are going to take your questions. Please be a little more patient. I'm going to quickly take them up very, very soon. All right, so moving on, Chand, I have another question, and this is regarding job market struggles for less experienced workers. So, which is the current processing time for I-485 applications for employment-based green cards? And are employment-based interviews still being waived by USCIS in most cases?
So for the last year filings, and when you talk about the I-485 processing time, we should be talking about the cases that are current as per the priority dates. If the date is not current, the 485 is just going to be sitting at the USCIS office until the date is current. So those timelines are very high, and because they have to wait until the date is current. But assuming the date is current and the case is getting filed, so normally we see approvals anywhere from 6 months to 1 year if the dates are current.
Okay.
And again, normally what I see every year is when the fiscal year starts. The fiscal year starts in October. The first one, two fiscal quarters, the fiscal quarter one, fiscal quarter two, USCIS tends to be very slow. Starting fiscal quarter three, that starts from June 1st, sorry, from July 1st. Sorry. The fiscal quarter three starts from April 1st. So that
Okay.
fiscal quarter, they start getting a little faster. And the final fiscal quarter, which is July 1st to September 30th, we normally see USCIS rush to uh, exhaust all their visa numbers. And the reason they become faster is because USCIS typically tries not to waste numbers as much as possible. At least that is what they've been doing in the last 2 3 years. So
Mhm.
due to that reason, normally they speed up things at the last minute if they feel that some visa numbers might get wasted. And in the first couple of fiscal quarters, what happens is they're kind of slow because they're doing more diligent checks. But not only that, they know that they have enough time to finish the visa numbers. The visa numbers get allocated October 1st, but USCIS has until September 30th of the following year to
Mhm.
finish all their visa numbers. So due to this, the timelines could vary, but we have seen a lot of green cards get issued as soon as early as in less than 6 months, and up to 1 year is probably what I would expect if the dates are current. And that being said, majority of the employment-based cases, interviews are getting waived. That being said, occasionally a couple of cases get interviews, and getting an interview does not mean anything because I did attend a couple of interviews along with the 45 applicants, and sometimes it is just random, sometimes it is probably to train another USCIS employee, and sometimes maybe there is a real good reason that USCIS wants to inquire and find out. But the employment based interviews are very rare, and even the interviews that
Mhm.
we have been seeing, and they're pretty straightforward. And normally if employee has maintained their status, because pretty much that is what they do when they go for a 485 interview for employment based cases. They check the employment history, they make sure there are no holes in maintenance of status, they make sure that that person is following the rules, there is no criminal history. And most of the time it's a pretty simple straightforward interviews. I typically see 30 minutes to 1 hour is the kind of interviews that happen. And
Mhm.
that being said, they are on a minority. The interviews are very, very few. Majority of the folks out there can expect their green cards without an interview for most of the employment-based cases, EB2 and EB3 cases.
Well, that's very interesting, and thank you so much, Chand, for giving us a good explanation on employment-based green card processing and interviews. And folks out there have a lot of questions, so I think I will not make them wait any longer. Chand, if you're ready, can I take some of the questions from our viewers out there?
Sure,
Yeah.
definitely. I think, yeah, let's take up viewers' questions.
Yes. So first one we should take up is Kumar Raj on YouTube asking, Sir, while presently in initial OPT, need your advice. Should I go with consular processing or change of status H1B filing?
Sure. So if somebody is on initial OPT, what that typically means is, assuming he's from STEM background, they are going to get 2 more years of STEM OPT. So initial OPT, which is 1 year, plus 2 more years of STEM OPT. And one thing everybody should understand is the H1B, it is only valid for 6 years. And if you want to exceed 6 years on H1B, you need to have the I-140 process done. Otherwise, you can't extend your H1. For a lot of folks nowadays, the perm process is taking extremely long times. So the company starts the process to get the I-140 approved, you're looking at 2 to 2.5 years of time. And since H1B can only be done for 6 years, I've seen a lot of times people getting into the fifth year and realizing that the H1B cannot be extended any further because they have finished up their 6 years of time. And this is where the counselor process versus change of status could get into a big difference. When you file for change of status, the day you get the H1B approved, you get an approval with change of status. So you automatically convert to H1B status. So your 6 year clock starts the day your change of status is effective. And when you go for consular processing, what that means is you have an H1B approval, but the H1B status is not given yet. So your H1B clock does not start yet. So if you spend more time on OPT, because you are eligible to spend time on OPT, you can use the
Mhm.
flexibility of OPT and finish up that entire time, which is like in your case, probably at least another 2 years, plus another 6 years on H1. So you can extend the timelines. So probably that's also a good reason why, in your case, counselor processing might be a better option than change of status filing. Because the only problem is you have to ensure that you go for stamping at that particular point of time. And while you're on F1, make sure you're completely diligently following the STEM OPT rules, which is uh, keep in touch with your school DSO, make sure your school DSO knows what's happening, you're submitting the school DSO reports, you're working as per the terms of the 983 and so on. So my suggestion is definitely consular processing is probably more attractive if you're still in initial OPT.
Thank you so much, Chand, for the detailed explanation. And we have some follow-up questions from Kumar Raj. His next question was, can we transfer to another company from present company during change of status H1B? And another one was, when can we file I-140 during COS?
Sure. Once the H1B is approved, whether it is council processing or whether it is change of status, that H1B approval can be used if you get a better offer and you want to transfer to another company. So theoretically, that can be done. So even if you have a filing done in council processing, that can still be used to transfer once that case is approved. And in terms of doing an I-140, normally my thing is the day you have a very good offer from a company and the company is ready to do your green card processing, the sooner the better. And even if you're an F1 OPT, if a company is impressed by your skills and they want to sponsor your green card, they can do it. We have done the perm processing, the I-140 processing for a lot of folks on F1. It can be done. And what that means is when you're an OPT and your employer is impressed by you and they want to offer you a permanent job and they want to sponsor your green card, I would say get it done. The more earlier, the more faster you get into this green card queue, you will be able to lock up your priority date. And for India, we already know that the priority date is heavily backlogged. And what that means is the sooner your employer, you can convince your employer, the better it is, because the employer has to be convinced that you're the right fit for their company and they want to sponsor you long term for permanent employment and so on. So my thing is, if you have a valid permanent job offer from a company, the sooner the better. You don't have to wait until you get an H1B approval.
There you go, Kumar. Thank you so much for your question, and thank you so much, Chand, for taking them all up. Moving on, let's take up Vishnu Vardhan. Hi again. It's always good to have you, Vishnu. I feel like you're very regular on our shows. So good to have you and your questions. So Vishnu is asking, what are pros and cons for EB1C versus EB2 green card? Which one to choose? What is timeline for each process? And can we ask employer to do both?
So EB1 is like a very good category. That is like the fastest category of getting a green card. EB2 is not as fast. So if somebody asks me like what is better, EB1C or EB2, hands down EB1 is always going to be the fastest way to get a green card when you compare it with EB2 in general. That being said, when somebody says which one to choose, the qualification requirements for both EB1C and EB2 are entirely different. If somebody qualifies for both, the answer is very easy. Definitely choose EB1C and see if the employer can file sponsor under EB1C. But not everybody qualifies under EB1C. EB1C is a category where somebody has worked in India for at least 1 year as a manager. And for that same
Okay.
company or an affiliate or a subsidiary company or a parent company, they want to come to US to work in US as a managerial in a managerial capacity. To give an example, somebody is working in TCS India office. They want to come to TCS
Mhm.
US office. Manager over in India TCS, manager in TCS US office. For those folks, EB1C is something that can be used because EB1C means it is for intra company managerial transfer. So you are moving within the same company from a foreign office to a US office in a managerial capacity. So for somebody who's in US, say you came here on F1 visa, you're working on F1 visa, and you never worked in the foreign office of that company, you will not even be eligible for EB1C. So that's why. So you have to look at whether you qualify. If you qualify, definitely ask for EB1. Employer can do both EB1C and EB2. If you qualify for both, employer can do both. There is nothing that says you can't do both. But there is no point. EB1C is going to be fastest. You don't have to do a perm labor for EB1C. So directly the company can file I-140, file it in premium, and don't even have to worry about EB2 because EB2 is very lengthy. You have to do the perm. The perm itself will take you about a year and a half. And then you have to do the
Right.
I-140. So you can skip all of that, directly go to EB1C if you are eligible. So the answer is check with your employer and see if you're even you meet the requirements. If you meet the requirements for both, definitely I would say EB1C is the best.
Absolutely. And all the best, Vishnu. I hope you make it to EB1C category. Thank you, Chand, for the detailed explanation. Now we have Anila, and she has, I see, a question or more in three parts. So this is saying, I filed my H1 to H4 6 months back in Vermont and not yet approved. Can I follow up with USCIS as I need to file for next extension before December 2024? I have filed for H1 to H4 conversion in March as my H1 6 years was getting over in September. I had to quit my job as H1 expired and H4 EAD not yet approved. If I get the approval soon, can I join back? The current H4 conversion, once it's approved, it will be valid only till December 2024. I need to file an extension again. Is there anything I can do to get the approval soon based on next extension file?
So if it is only 6 months, my guess is USCIS will claim you're still within the processing times, but you can definitely call USCIS, try to raise a service ticket, and see if it is beyond the published timelines. And if it is beyond the published timelines, the when you call USCIS, they'll be able to open up a service ticket for you. So that is one option. That being said, if you are only eligible for an extension only until December, what that means is you definitely, whether that case is still pending or not, you should still file for an extension because you know that initial case that you filed, it's only going to be approved until December. So definitely you have to file for an extension. And if you want to speed up the process, normally what we suggest is your spouse. My guess is even your spouse is probably going to have an expiration in December, because if you are needing to file an extension, because your H4 is only going to be valid till December, his H1B
Mhm.
also is probably only valid till December. And if he's filing for an extension, if you combine your H4 application, his H1B petition, put it in the same package and do a concurrent filing. When you do a concurrent filing and you do it in premium, normally what USCIS does is they will process everything at the same time. So in your case, you can do the H1, H4, H4 EAD. If your husband is also applying for an extension, file all three together in the same package, do a concurrent filing, do it in premium. You will definitely get an answer in premium processing. And that is like the best case scenario. But if you can't do that, definitely you will still have to file for an extension, because the previous case is only going to get approved till December, which means that you should still go ahead and file an extension.
All right. Thank you so much for taking that up for Anila. And Anila, I hope that you figure out, and all the best. Thank you for your questions. Thank you for participating. If you have any further questions, we are here for a little while more. So please feel free to drop them in the comments. Now moving on, we have Yugandhar. This is also on YouTube. Hi, sir. He says, my I-797B got approved, but my name on the document got truncated. Last four characters will be, will that be an issue? What do I have to do further? Thank you.
Sure. So, I mean, we very routinely see it. If your last name or your name is like very, very long, on the approval copy, they will typically truncate any of the final characters that don't fit into their field. So my guess is, if it is one of those cases where your name is long and the four characters got truncated because the name is long, it is probably by design, and that should not cause you any issue at all. And if you talk to your attorney, they will be, I mean, to the attorney who filed the H1, they will be able to immediately tell if it is because your the length of your name crossed that character limit or not. If that is the case, there is no issue. Simply, you're good for stamping. I absolutely don't see any issue. The reason is, underlying the H1, USCIS will have a copy of your passport and copy of your petition and everything. And the council will have a copy of it. So they'll be able to match it up. That should not be a problem. Then again, if it is a typographical mistake, if it is a small last name, but it is an accidental mistake, you think it's a typographical mistake. Normally, what you can do is you can ask your employer or your employer's attorney to create a service ticket. And if you create a service ticket, if it's a typographical mistake, USCIS, they will typically send you the amended approval copy. And it's a very easy process. It should not be a problem. And until the day they send you that amended approval copy, you can still utilize the current existing copy with the typographical mistake.
All right. Thank you so much. And Yugandhar, all the best. I hope you got your answer. Thank you for your question also. Now we have Satish, also on YouTube. He's asking, I am on H4 EAD and my wife is on H1B. Can she take break from working during pregnancy for a few months and can I still work on EAD during that period? How should we plan? Thanks.
Sure. So one of the very primary rules is if the spouse is on H1B, the dependent, so the H4 person who's holding the H4 EAD, the H4 person is in valid status only if the H1B spouse is in valid status. So as long as the spouse is maintaining a valid H1B status, there is no issue with H4 EAD. And what that means is taking a break for medical reasons, is it still maintaining status or not? And the answer is if somebody is taking a medical leave, in this case for pregnancy, you will still be able to maintain status. Make sure your employer, her employer, the H1B spouse's employer, knows that it is a medical leave, knows that she's only taking time off, and they're not terminating her employment. So as long as the company does not terminate her employment and they've granted her that leave for medical reasons, both of you should not have any issue, and you should be able to continue working on your H4 EAD. You should be able to maintain your status, and your spouse, because she's taking a proper voluntary leave, she should not have any issue in the future.
All right. So, all the best, Satish, and congratulations. I think new family member on the way. So, all the best. Thank you. Thank you, Chand, for taking that up. Now we have another one. This is from Karthik Rahman. This is on YouTube. Hello, sir. Can we travel out of the country if we have I-539 change of status for H4 in progress? When the principal applicant of H1 has changed the job and transferred to the new employer.
Whenever you have something called change of status, one status to another status, anytime you have a change of status application pending, there is a rule that says you cannot travel out of the country. And what's going to happen? So if somebody has this change of status case filed and then you travel out of the country, that application, that change of status part of that application will get denied. And the way to fix it is you go for stamping. So for example, you have I-539 change of status. So if it clearly says change of status in the 539, you travel out, the application will get denied. But what you can do is you can simply go for stamping and get a visa and then come back. So uh, USCIS will deny the change of status, but you can always go to the consulate and get stamping. So again, this case, I think check with your attorney, because normally the attorneys will recommend not to travel when there is change of status because of the hassles you have to go through to get visa stamping and so on. But that is a solution. If you don't have a choice, you have to travel. The change of status will be denied, but you approach the consulate and then get stamping.
All right. Thank you so much, Karthik, for your question. And thank you, Chand, for taking that up for Karthik. Now we have Neha. This is also on YouTube. Thank you, Neha, for your question. Hi, Chand Parvathaneni and Nipasa. Hi, hi to you, Neha from India. She filed her H1B petition and still no change in status and under actively reviewing. When do I get my status update?
Sure. And again, unfortunately, USCIS is having very wide range of timelines for approvals. We had some cases get approved in less than a week, regular processing cases. And then even we have some cases that have passed 6, 7 months for H1B, which are still under active review. And the reason for that is, especially for the lottery filings, the cap filings, USCIS gets a lot of filings. I mean, 85,000 is what are allocated. But because we had a second lottery, my guess is probably around 70,000 got filed in the initial lottery. And there is no way they can process all 70,000 on the same day. And they have to start somewhere. So what happens is some cases get to top of their pile and then slowly start clearing out that pile. That's why some people get an approval for these cap cases very quickly. And some people are waiting and waiting and waiting because USCIS has to start from the top and get to the bottom, to the very last case. And what that means is, since they can't do it in one day, some cases on the top will be very quick, some cases on the bottom will take time. And normally by the time October hits, we see like 60-70% of the cases done. October, November, December, I would say majority of the cases will be completed, at least the initial review, either an RFE or an adjudication. And my guess is you're probably very close. In the next month or so, more than likely you will see something. But again, it is it is not uncommon to see cases still being under initial review even after 3 to 4 months.
Okay, so I would say you just have to be a little more patient, Neha, and look out for good news, but not to worry. I think this is very common. So, all the best. Thank you for your question, Neha. Thank you for participating, and thank you, Chand, for the detailed explanation. Well, now we have, Kumar Raj has a follow up question. Thank you, Kumar Raj, again. Sir, can the consular process be converted to change of status before expiry of STEM OPT?
Sure. So, say the initial H1B petition went in as counselor and you were given counselor approval. And at some point down the line, for example, in your case, you realize that your STEM OPT is coming to an end, and like 2 or 3 months before, uh, you basically reached out to your employer. The employer can file a new H1B requesting change of status. And what they do is they still have to file a new H1B, and they would use your old approval to prove that you're cap exempt, that you don't have to come through the lottery. But they definitely will have to do a new filing requesting change of status, pay the entire fee again. So the problem is, yes, you can do it, but again, you're having to pay for that USCIS fee. I mean, the company has to pay for the USCIS fees all over again, and the cases can take 3 to 6 months. So what we suggest is don't really wait until the very last minute, because if you wait until the very last minute, when it's closer to your STEM OPT expiration time, you don't have a choice but to do it in premium, and premium is expensive. Premium processing for H1B is $2,805, the government fee. So if you start a little early, like 3 to 6 months early, and the case gets filed, more than likely in regular processing, you'll be done. If you wait too long, you can still do it. It's just that you might have to do it in premium processing, and then the company's case gets a little bit expensive.
Expensive, right. Time and tide waits for none, so make sure you make your time count. And thank you, Kumar, for your question. All the best. Thank you, Chand, for taking it up. We have Anila also with another follow up, so let's take it up first. And Fagun, we are coming to your question. Please stay with us right after Anila's. Anila's asking, am I allowed to file for H4 and H4 EAD extension with my husband's H1 extension, even though my initial H4 and H4 EAD application is currently in progress?
Yes, you are definitely allowed to file, and we have filed in the past. And I think definitely you should file along with the extension. And as a part of that extension, just annotate that your prior case is still pending, because you do have to prove maintenance of status. And to prove maintenance of status, you have to prove you have to give the old receipt number and show that the old receipt is pending. And because the old receipt is only valid, the old application, since it can be done only till December, this application is for approval from basically after December. So you can do it on the I-539, because I-539 will have a start date. So you can do it on I-539. You can annotate, and you can let USCIS know that the other case is still pending, and it should not be a problem. The advantage filing with your husband's case is that if you file the husband's case in premium, they'll do everything in premium. So that way you don't really have to wait long, which you have been doing with your the initial case. So file it simultaneously, do it as a part of that same a package, and state to USCIS that your initial application is still pending. And even if you don't, they will still see it, because they will see that your current status, you don't have current pay stubs because you filed for a change of status, and then they will see the H4 receipt, so they will understand. Okay, so it should not be a problem, and I would definitely suggest you do it along with your husband's case, because if you do a concurrent filing, there is a legal settlement that happened earlier this year, due to which they will process everything simultaneously. So both the H4 EAD and H1B, they will do it simultaneously if the filings are done concurrently.
All right. Thank you so much. And thank you so much, Anila, for your question. Also, at this moment, I would just love to say to all you folks out there, especially those who have commented and who got answers from our guest today, Attorney Chand Parvathaneni, please do not forget to like our content, like, share, and subscribe also to our channel, Immigration and Jobs Talk Show. We are there on YouTube, LinkedIn, Facebook, and also on X, that is Twitter. Please connect with us. And also, don't forget to contact Attorney Chand Parvathaneni if you're looking for a one on one consultation and you want to connect further regarding your case. You can always call him. This is his number, 817-523-8247. And you can email him law@spblawfirm.com, and definitely go visit spblawfirm.com to get to know more about Attorney Chand Parvathaneni and SPB Law Firm. Thank you, Chan. So far, so good. Really lovely to have all the folks out there with their questions. And I have a few more to go. So let's take up this one from Fagun on YouTube. Hello, sir. He says, I am currently on my OPT extension. I got selected in the second round H1B. I will be filing my H1B application by the first week of October. There is family emergency in India. Can I leave? Will there be any problem if I leave USA? My OPT extension is valid till June 2026. Will me leaving in October cause problem to my H1B application?
So in this case, I think if you talk to your attorney about your travel plans, more than likely they will ask you to do it in consular processing and not as change of status. If you file your case as change of status, you go out of the country, the change of status part gets denied. And what that means is you should do it in consular processing. And if you do it in consular processing, you have two options. When you're in India, you can get stamping and come back on H1B, or you can simply come back on OPT and start working on OPT, as you already confirmed that your STEM OPT is valid till 2026. So in your case, clearly you are a very good candidate for consular processing. And my guess is more than likely that is what your attorney is going to suggest and do. File your case in consular processing so that way you can travel. You come back on OPT, you work on OPT, and at some point down the line, you again have to go for stamping for H1B.
Okay. Thank you so much for that detailed explanation, Chand. And thank you, Fagun, for participating with your questions. If you have any further questions, please feel free to keep commenting. And Anila says thank you. Thanks to you too, Anila, for your questions. Thank you for participating. Well, now we have Vihan with his questions. There are two parts to this, also on YouTube. Great points you made. Well, that goes to you, Chand. And could you elaborate on how to handle this? My H1B got approved in consular process, premium processing. My employer is planning to apply for change of status. My question is, do I need to pay for premium again for COS, change of status, or the premium processing fee which I paid earlier for my H1B approval is sufficient?
So unfortunately, the premium processing fee is tied to the receipt. So every time you file a case with USCIS, you have to pay the fees all over again. I mean, the I-129 fees gets paid, and the premium processing fees has to be paid all over again if you want an expedited decision. And that's why normally what you should
Okay.
do is you should probably file the case as early as possible for change of status. So that way you can use your STEM OPT, and before your STEM OPT expires, you'll get your change of status approved. But if you want a quick answer and you're getting close to your OPT expiration date, then you won't have a choice. You have to do it in premium. And unfortunately, to answer your question, you do have to pay the premium processing fees again. The H1B fees cannot be paid by you. Only the company has to pay. But the premium processing fee, which is the 2,805, that can be paid by you or the company.
Okay, so Chand, do you suggest as soon as we get our H1B, so get change of status done as soon as we get it? Is that it? Is that right?
I mean, if somebody has OPT, I mean, you don't have to rush, because if somebody has, for example, 2 years of OPT, you have a lot of time. But at least, I
Hmm.
mean, don't wait until it's the last month. At least 3 to 4 months before your OPT expires. So probably you can check your
Okay.
OPT EAD card and see when your OPT status expires. At least 3 to 4 months prior to that, probably it's a good idea to file change of status. Or if you have travel plans, go to India and get stamping. If you go to India and get stamping, you don't even have to do a change of status filing. That visa stamp is enough.
All right. All right. Thank you so much, Chand, for the detailed explanation. And also, Vihan, thank you for your question earlier. And now we have another question. This is from Ishita, also on YouTube. I filed for an H1B change of status, but my petition is pending. What are the implications if my current visa expires before the decision? And what options do I have to maintain my status?
So, in general, whenever H1B is filed with change of status, the company more than likely put October 1st as the start date. And up to October 1st, they have to ensure that they have valid status. And after October 1st, even if status expires, as long as the H1B petition is still valid, the person can stay back in the country. So they can stay back and wait until this H1B is adjudicated. If the H1B is denied, they have to leave the country immediately. If not, because the H1B has been filed, and as long as that H1B is a non frivolous filing, genuine filing, they should not have any issue because H1B lets them stay in the country while it's in process.
Great. That is great. So, all the best, Ishita. And thank you for your question. Thank you, Chand, for taking this up for Ishita. We also have follow ups from Vishnu. So, I think we should take them up again. Vishnu Vardhan. If I get I-140 for EB1C and I stayed in the company for 6 months, can I still use it for other company to extend my H1B and H4 EAD? Because in the new company, as a part of H1B transfer, I might not join as a manager. Then, do you think I-140 under EB1C becomes invalid and should I do EB2 perm again in new company?
Sure. Um, so, in this case, since you're staying in the company for at least 6 months, what that means is that I-140 is valid. So for your H1B extensions and H4EAD, there is absolutely no issue. However, the new company cannot do a EB1C because EB1C is the same company, intra-company manager transfer. So the
Yes.
new company will still have to do EB2, and what that means is they have to go through the lengthy process of doing the perm and then
Oh.
I-140 and so on. The
Mhm.
only good thing, the only advantageous thing for you is when they finally finish their I-140, you can recapture the priority date from the initial EB1C approval. So your priority date will still carry on. So whatever is the old priority date, you will get that date. But unfortunately, the category will be EB2. That's what typically happens. But there are some folks out there who have been able to file the EB1 I-485. So they are able to file I-485 using your EB1C I-140 approval because your dates are current. If that is the case and you wait for 180 days and then you move out of the company, then you don't really have a problem at all. You don't even need a green card. You don't even need a perm process again. So if I-140 is filed, 485 is filed, and then you wait for 6 months, pretty much the new company does not even have to do the EB2 perm process. But unfortunately, in your case, if the I-140 date for EB1C for you, the priority date for you did not become current, in
Mhm.
that case, if you move out of the company, the new company will have to do a perm in EB2 category. The only silver lining is you'll be able to get your retain your priority date.
Okay. So, all the best, Vishnu, and thank you so much for your questions. I hope you resonated with the answers from Chand, and thank you so much, Chand, for taking this question up for Vishnu also. Fagun says, "Thank you, sir. That is great. Thank you so much, Fagun, for your question also and for participating. And I think with this, we will have to wrap up our show. Unfortunately, we are running out of time, but we do want to have an end note from Chand. So, with regard to what we discussed today, Chand, I mean, we would love it if you have to say anything about, today's topic, facing H1B change of status challenges. And what do you have to say to all the folks out there who participated and who are watching us right now?
Sure. Since October 1st is the start date, a lot of the folks are going to be having the approvals for the very, very first time. There are uh, some pointers. Every person who has an H1B filed, they should get a copy of their LCA. they can talk to the company and get a copy of the LCA. It is the company has to give the LCA to the employees. It's a mandatory requirement. A company cannot say that they cannot disclose the LCA. So everybody should get a copy of their LCA, because you want to make sure tomorrow when you're working as per the terms of the LCA. So very important thing, request your employer for the copy of the LCA if they've not already released it. And then the second point is, make sure you get a copy of your approval. And before starting to work, make sure you have an I-94. So every H1B will have an I-94 on the bottom. And if you have an I-94, you can start working for the company as per the terms of the H1B. If you do not have an I-94, you might have to go get visa stamping or file another change of status case. So always look for that I-94 if you're about to begin working from October 1st with change of status. That's another important thing. And another important thing is, a lot of people move from F1 to H1. And on F1, a lot of folks have this exemption where they don't pay the social security taxes and Medicare taxes because of some exemptions. And on H1, there is no exception, no exemption. So check with your employer in case you're working for the same employer on F1 OPT and converting to H1 from October 1st. Make sure the payroll changes are done appropriately, and check with your employer, because sometimes we see that people realize it late and they come back, they have to amend their taxes, they have to do a whole lot of extra work. So anybody who is on F1 who got an approval with change of status, talk to your company's payroll. Make sure they're deducting all the FICA taxes and the social security SSN taxes uh, correctly as per your H1B status, because things are a little bit different on the F1 status. That being said, I mean, good luck to a lot of the folks out there who already received their approvals, can start from October 1st. And for others, I think the H1B process lately has been pretty smooth. And all the best with your H1B process.
Absolutely. Thank you so much, all of you, for joining us today on Immigration and Jobs Talk Show. I really hope that today's discussion on H1B change of status provided some valuable insights and answers to your questions as well. And definitely a special thanks to our guest for today, Attorney Chand Parvathaneni, for sharing your expertise and walking us through the complexities of this important process. And your insights have been incredibly helpful. Thank you so much, Chand, once again, and really good to have you here.
Thank you, Nipasa.
So, friends out there, you can contact Attorney Chand Parvathaneni, and the details are on the screen. You can call him on this number 817-523-8247. And you can also go visit law at spblawfirm.com to get to know more about Attorney Chand Parvathaneni and also the law firm. And you can email Attorney Chand in case you want to have a one on one consultation or you want to have further discussions on your case. Law at spblawfirm.com. That is the email address. Thank you, Chand, once again. You have a great day, and I hope to see you soon again.
Thank you, Nipasa. Bye bye.
Bye bye. So, to everyone tuning in on YouTube, Facebook, and LinkedIn, thank you so much. We really appreciate your engagement and participation. And if you have more questions or need further guidance, please don't hesitate to reach out to us and drop all your questions in the comments because we are here to provide you with answers. And remember to like this video, share it with those who might benefit, and subscribe to our channel for more discussions on immigration and employment. So, we'll be back with more informative sessions, and don't forget to stay tuned to Immigration and Jobs Talk Show. And until next time, take care. Thank you so much for being with us today. Bye bye.